The United States Supreme Court has just stepped directly into one of the most significant constitutional battles in decades. And if you care at all about your fundamental rights under the Bill of Rights, you need to pay very close attention right now. This is not some minor procedural dispute buried in legal paperwork. This is not a technical argument that only attorneys and judges care about. This is a case that could completely reshape how criminal trials work in multiple states across the country and restore protections that millions of Americans have been quietly denied for over 50 years. And the fact that the Supreme Court moved swiftly to take this case is already sending shockwaves through the entire legal community. Every year, thousands of petitions are filed before the Supreme Court. The overwhelming majority are rejected without a second glance. Yet in this situation, the justices decided that this issue was important enough, urgent enough, and significant enough to deserve their immediate attention. That decision alone tells us something powerful. When the Supreme Court grants review in a major constitutional dispute, it is a signal that at least some members of the court believe a serious legal problem exists. The court does not spend its limited time revisiting settled questions unless there is a compelling reason to do so, and that is exactly why legal observers across the country are paying extremely close attention to what just happened. This Monday, the Supreme Court dropped a bombshell by granting immediate review in a high-stakes challenge that strikes at the very heart of the Sixth Amendment, your right to a trial by jury. On paper, it started as a local licensing case in Florida, but it has exploded into a full-blown constitutional fight over what the founders actually meant when they promised every American the safeguard of a jury trial. And right now, the conservative majority on the court appears ready to slam the door shut on a loophole that 6 states have been quietly exploiting to shortchange your constitutional protections for more than half a century. If you believe your right to a fair trial is rock solid, think again. Some state governments have been shrinking your jury from the traditional 12 citizens down to just 6, making it dramatically easier to secure convictions against ordinary Americans. Today we are breaking down exactly what just happened, why it matters to every single American, and why anyone who values their constitutional rights should be watching this case with intense focus. To understand why this decision sent shockwaves through the legal community, we have to start with the facts that brought this case all the way to the nation's highest court. The petitioner is a Florida man named Keon. He was charged by state prosecutors with multiple felony counts of practicing chiropractic medicine with a suspended license. Serious charges, without question. Under normal circumstances in a federal court, Keon would have been guaranteed a full 12-person jury to stand as a buffer between him and the full power of the state. That buffer is not a courtesy. It is a constitutional guarantee. It is one of the crown jewels of the Bill of Rights, a direct shield against government overreach placed there intentionally by the founders. But Florida, along with 5 other states, Arizona, Connecticut, Indiana, Massachusetts, and Utah, has carved out an exception for non-capital offenses. These states shrink that constitutional shield down to a 6-person jury. Keon was forced to face trial before one of these smaller panels. He was convicted and sentenced to more than a year in prison plus 5 years of probation. Instead of accepting that outcome, Keon fought back hard. He demanded his full Sixth Amendment right to a traditional 12-person jury. The case went up to the Florida State Court of Appeals, but they rejected his arguments outright. The appeals court leaned on a 1970 Supreme Court precedent called Williams v. Florida. In that older ruling, the court used a cost-benefit analysis and essentially said that a smaller 6-person jury could still deliver justice just as effectively as the historic 12-person model. The court at the time weighed convenience against constitutional protection and decided that convenience won. That reasoning has stood for over 50 years. Keon refused to back down. He took the fight all the way to the Supreme Court, arguing that Williams v. Florida is outdated, that it should be overruled, and that the era of watering down the Bill of Rights needs to end right now. His petition makes a powerful case that modern Supreme Court precedent has shifted dramatically since 1970, and it is time for the justices to align the law with the original understanding of the Constitution. At its core, this case centers on a question that sounds simple, but carries enormous weight. Can government officials place limits on a constitutional right that the founders intended to be fully protected? Or does the Constitution mean exactly what it says, regardless of administrative convenience, political pressure, or changing public opinion? That question may sound straightforward, but the answer could affect countless Americans across the country, and the Supreme Court's decision to take this case suggests the justices believe the current answer is wrong. For years, courts, lawmakers, and government agencies have relied on legal frameworks that allow restrictions on constitutional rights, as long as the government can point to sufficiently important reasons. Supporters of those frameworks claim they are necessary for practical governance. But critics argue that this approach has gradually weakened protections that were originally intended to be strong, fixed barriers against government overreach. Once courts begin weighing constitutional rights against government interests, the government almost always argues that its goals are important enough to justify the restriction. Public safety is important, administrative efficiency is important, saving money is important. Government officials can point to an endless list of objectives they believe justify shrinking your rights. According to the challengers in this case, that process effectively transforms constitutional guarantees into negotiable privileges. And that is precisely the argument now sitting before the Supreme Court. This is exactly why you can never assume your rights are automatically safe. Governments at every level are constantly looking for ways to chip away at the protections the founders put in place, often under the excuse of saving money or making the system more efficient. The founders were not naive about this. They had just fought a revolution against a tyrannical system where the king could stack the deck against citizens in their own trials. They had lived under systems where distant authorities could rig proceedings with hand-picked decision-makers. 12 jurors drawn from the local community represented the collective judgment of the people, not the government, and they built the Sixth Amendment as a hard wall against exactly this kind of erosion. Now you might be wondering why the Supreme Court suddenly decided to take this case after nearly 50 years of letting the six-person jury system operate without challenge. That is the most revealing part of this story. Keon's petition brilliantly corners the court using their own recent logic from landmark decisions. He points directly to the 2020 case Ramos versus Louisiana. In Ramos, the Supreme Court struck down non-unanimous jury verdicts and made it crystal clear that the Sixth Amendment must be interpreted exactly as it was understood in 1791 when the Bill of Rights was ratified. The court in Ramos explicitly rejected the kind of flexible cost-benefit balancing that was used back in Williams versus Florida. They said it is not the job of modern judges to decide which historic features of a jury trial are important enough to keep and which ones can be discarded for convenience. The Constitution does not come with an asterisk, allowing states to redesign its protections whenever those protections become inconvenient or expensive. Keon's argument is rooted in strong originalism. At the time of the founding, the word jury had a very specific and universally understood meaning: 12 ordinary citizens from the community sitting in judgment of their neighbor. The founders did not include fine print allowing states to downsize that protection to save money or speed up prosecutions. What makes this challenge so strategically powerful is that the petitioners are not asking the court to invent a new constitutional rule. Instead, they are arguing that the court should consistently apply principles it has already embraced in other major cases. Over the last several terms, the court's conservative majority has repeatedly emphasized a constitutional methodology focused on text, history, and tradition. Rather than relying heavily on balancing tests or policy considerations, the court has increasingly looked to the original understanding of constitutional provisions when evaluating whether government action crosses a constitutional line. That shift has already produced major changes in several areas of constitutional law. Keon's team has built a compelling originalist argument that aligns perfectly with this current methodology. They have shown through historical records that at the time of ratification, juries of 12 were the universal standard for serious criminal cases in every jurisdiction. There was no debate about this. There were no asterisks, no exceptions for efficiency. A jury meant 12 people, period, and that was the protection the founders wrote into the Constitution. If the justices stay consistent with their own recent reasoning, Williams versus Florida looks increasingly difficult to defend. The reaction from government officials has been telling. Florida's Attorney General knew exactly how dangerous this case was for the status quo. They filed a strong brief opposing the Supreme Court taking the case, essentially asking the justices to leave things alone. And in that brief, the state openly admitted that overturning the old precedent would imperil thousands of active criminal convictions, not just in Florida, but in Arizona, Connecticut, Indiana, Massachusetts, and Utah as well. Think carefully about what that admission reveals. Governments have been relying on this loophole for over 50 years, and now they are beginning to panic because the Supreme Court has signaled it might tear that loophole wide open. Convictions that were secured with only 6 jurors could suddenly be vulnerable to challenges. We are talking about a potential cascade of appeals, retrials, and overturned verdicts that could flood the courts across those 6 states. This is the kind of shockwave that does not just affect one defendant. It could reshape the entire criminal justice landscape in nearly a dozen jurisdictions overnight. Critics of the petition argue that a sweeping ruling could create significant legal uncertainty. They warn that if the court overturns established precedent, countless future lawsuits may follow. Existing regulations could face immediate challenges. Long-standing legal assumptions could suddenly become vulnerable. And government entities may be required to adjust policies that have been in place for decades. Supporters of the challenge respond with a straightforward principle: constitutional rights are more important than administrative convenience. If a legal doctrine conflicts with the Constitution, it should not survive simply because governments have grown comfortable relying on it. From their perspective, constitutional protections do not become less important over time. They become more important because every year that an unconstitutional practice continues, thousands more Americans are denied the protection that was promised to them. The Supreme Court has a strong conservative majority that has shown increasing willingness to revisit and overturn precedents that stray from the original meaning of the Constitution. We have seen it with gun rights in Bruin. We have seen it with non-unanimous juries in Ramos. We have seen it with religious liberty. We have seen it in case after case where the court has drawn a hard line and said that the Constitution means what it says. This feels like the next logical step in that originalist revival. By granting review so quickly and decisively after nearly 5 decades, the justices are sending a clear signal that Williams versus Florida may be on very shaky ground. But let us zoom out for a moment and talk about why this matters to you personally, even if you never plan on practicing any kind of licensed profession without a valid credential. The Sixth Amendment is not some dusty technicality that only kicks in for other people. It is a protection that applies to every single American who might someday face a serious criminal charge, and in the current legal climate, that population is larger than most people realize. Technical violations, regulatory infractions, and increasingly aggressive prosecutions by hostile government officials have put ordinary citizens in legal jeopardy in ways the founders would have found shocking. Your jury is your last line of defense when the government has turned its full resources against you. Shrinking that jury from 12 to 6 does not just change a number, it changes the entire dynamic of the trial. The math is straightforward, and it is dangerous. With a 6-person jury, a prosecutor only needs to persuade a smaller group to reach a verdict. Group dynamics shift dramatically at smaller sizes. A single holdout juror becomes far more powerful and effective in a 12-person panel, forcing deeper deliberation and protecting against rushed or biased outcomes. 12 diverse community members are harder to pressure, harder to manipulate, and more likely to bring genuinely varied perspectives to the deliberation room. The founders understood this from experience, not from theory. They designed the 12-person jury specifically because history had taught them that larger panels are a more reliable shield against both government intimidation and simple human error. Now, the timing of this grant of review is also significant from a broader constitutional perspective. When the Supreme Court agrees to review a challenge of this magnitude after 50 years of silence, every government entity potentially affected by the outcome begins preparing for what may come next. And that preparation is already underway. Supporters of the challenge believe the court may be preparing to significantly strengthen constitutional protections and impose real limits on state authority to dilute those protections. Government officials argue that such a move could create massive uncertainty and disrupt legal frameworks that countless prosecutions have relied upon. Both sides understand exactly what is at stake, and neither side appears willing to back down. This case is not happening in isolation. It is part of a broader constitutional transformation that has been building across multiple areas of law. Entire regulatory systems could face new challenges depending on how broadly the court writes its eventual opinion. Existing precedents could come under renewed scrutiny. Government agencies could find themselves defending policies that were previously considered completely settled, and courts across the country could be forced to reconsider legal doctrines that have existed for generations. That possibility helps explain why some officials are watching this case with a level of concern that far exceeds what a single criminal conviction in Florida would normally generate. At its deepest level, this case forces the court to answer a foundational question about the nature of constitutional rights themselves. The founders designed the jury trial right as a bulwark against government tyranny. They placed it in the Constitution not as a suggestion, but as a command. Not as a starting point for government officials to negotiate downward, but as a fixed limit on state power. Supporters of the challenge argue that once judges begin modifying constitutional protections to accommodate modern policy preferences, the Constitution gradually loses its ability to function as a genuine safeguard. Rights are strongest when courts focus on constitutional text and historical understanding rather than on what outcomes seem most convenient for the system. This is a principle that extends well beyond jury size. The same logic that allowed states to shrink the jury from 12 to 6 could justify future erosions in other areas of constitutional protection. If governments can point to cost savings or efficiency gains to justify reducing Sixth Amendment protections, what stops the same reasoning from being applied elsewhere across the Bill of Rights? That is the precedential danger that Keon's petition is really asking the court to address. Not just the specific question of 6 versus 12, but the broader question of whether the Constitution establishes fixed protections or adjustable guidelines. Of course, we have to remain realistic about what comes next. The Supreme Court has agreed to hear the case. Oral arguments will take place next term. The justices will review the full record, ask their questions, weigh the historical evidence, and ultimately issue a decision. Nothing is guaranteed until that final opinion is released. Even with a strong conservative majority, the court can surprise observers, issue narrow holdings, or find unexpected paths to a ruling. But the mere fact that 4 or more justices saw enough merit in Keon's petition to grant certiorari after 50 years of precedent is itself a major development. That is not something the court does lightly. What we do know is that the court's willingness to step into this fight has already changed the conversation in a fundamental way. What was once considered a settled issue is now being re-examined. What many assumed was established law is now being directly challenged. And what state governments viewed as secure authority is now facing hard scrutiny from the highest court in the nation. Prosecutors in those 6 states are already on edge. Defense attorneys in those jurisdictions are gearing up for what could become a flood of new motions and appeals. This is not just legal housekeeping. This is a fundamental recalibration of the relationship between the citizen and the state. The potential restoration of full 12-person juries nationwide would be a massive victory for individual liberty and for the original vision of constitutional governance. It would force states to respect the founding-era meaning of the Constitution instead of treating it as a document they can quietly edit whenever compliance becomes inconvenient. Every American who values fair trials, due process, and meaningful limits on government power should be paying close attention to what happens next. The coming months will be critical, every filing will be closely watched, every moment of oral argument will be carefully analyzed, and every signal from the justices will be examined for what it reveals about where the court is heading. This nation was built on the principle that certain rights stand beyond the reach of temporary majorities, political convenience, or bureaucratic cost-cutting. The jury trial right is not a modern invention. It is not a policy preference. It is a foundational protection with deep roots in English common law, Revolutionary-era thinking, and the original constitutional text. For 50 years, 6 states have quietly operated outside the boundaries of what the founders intended. Now the Supreme Court has stepped in and signaled that the era of treating the Bill of Rights as a flexible guideline rather than a binding command may finally be coming to an end. The constitutional battle is now officially underway. The stakes could not be higher, and the nation is watching to see whether the Supreme Court will restore the protection that millions of Americans were promised but quietly denied. As this case moves toward oral arguments, every development will matter, because the final ruling could determine not just the fate of thousands of existing convictions across 6 states, but the future direction of constitutional law in the United States for generations to come. Stay informed, stay engaged, and never forget that constitutional rights only remain strong when citizens understand them, defend them, and refuse to let them be quietly taken away.